Hello, this is Dr. A, and I'm bringing your Chapter 11 Healthcare Law lesson. This is from the 5th edition of Basics of the U.S. Healthcare System, and we're going to start with an introduction here. So, to be an effective healthcare manager, it is important to understand basic legal and ethical principles that influence the work environment, including the legal relationship between the organization and the consumer. So that's the healthcare provider and the patient. And so when you enter the healthcare as a workforce, you will be usually on the provider end, and then you may, of course, be in a management position too. So it is important as an employee, as an employer, as a consumer to know all of these legal issues. So let's look at basic concepts of healthcare law. So first, law is a body of rules for the conduct of individuals and organizations. So it is often interpreted differently and may change over time. It is created so there's at least a minimal standard of action required by individuals and organizations. And it is created by federal, state, and local governments. As the judiciary system interprets previous legal decisions regarding a case, they are then creating common law. Okay, so this is the big first primer, and you have to know that usually federal law is kind of the umbrella that applies to everybody, and your state laws have to always meet the minimum of the federal. They can go beyond, but they can't. They have to usually abide by at least whatever the federal law is. And same with the local falling underneath the state laws. So, again, the minimal standard of action is federal law, although state laws could be stricter. And legislature creates laws that are called statutes. Both the common law and the statutes are then interpreted by administrative agencies, and they develop rules and regulations that interpret the law, and then those are published, and then companies use those rules and regulations to be in compliance with the laws and statutes that have been put out. They are civil and criminal laws that can affect the healthcare industry. So the civil law will focus on wrongful acts against individuals and organizations based on contractual violations. So there was a contract to care for a patient, something wasn't done, patient was injured, something like that. Those are all civil law types of cases. Torts, derived from the French word for wrong, are a category of wrongful acts in civil law which may not have a pre-existing contract. Think drug or device lawsuits. So if you get an implant or something, you don't have a contract with the manufacturing company. You just simply, you've agreed to the procedure, knowing that it would be beneficial, but then there's something wrong with the device, there's a recall, there's something, you get injured, and then you're not the only one. So then it's where you can have these mass torts, big lawsuits against a company that made the device or the drug. So to prove a civil infraction, you do not need as much evidence as in a criminal case. Criminal law is concerned with actions that are illegal based on court decisions. In order to convict someone of a criminal activity, it has to be proven without reasonable doubt of guilt. So examples of criminal law infractions in healthcare would be Medicare and Medicaid fraud cases. So let's talk a little bit about medical malpractice. According to the American Heritage Dictionary, medical malpractice is the improper or negligent treatment of a patient by a provider which results in injury, damage, or loss. This could apply to more than just doctors, although doctors are the ones that we typically think of when we think of medical malpractice. According to the IOM's landmark report To Err is Human, medical malpractice has resulted in approximately 80,000 to 100,000 deaths per year. So these are deaths that can be attributed to medical errors, and so that could have been prevented. And so that is a lot in the U.S. This is in the U.S. per year. Disputes over improper care of a patient have hurt both providers and patients, because I'm sure as a doctor that wants to provide good care to patients, getting sued by a patient probably doesn't feel really good. And a patient puts the trust in a doctor, and if they have an adverse effect, of course, they can be hurt. And I understand how this can all happen, and seeing that there are, close to 100,000 deaths per year from errors, medical errors, and this is just deaths. I mean, that there are a lot more medical errors than that, because there are a lot of errors that don't result in death, right? So patients have sued physicians because they feel their provider has not provided them the proper level of care compared to the standard of care in the industry. So this is an important concept of the standard of care, and it has become, there are national standards now for a lot of the way medicine is practiced, or different professionals practice. And so it's very important for you to know what the standards of care are in your industry. According to BAL, the injured patient must show that the physician acted negligently in rendering care and that such negligence resulted in injury. So negligence meaning they didn't do something they were supposed to do, right? Fail to give a medicine, or fail to do the proper treatment, or maybe even miss a diagnosis or something like that, and then that caused the patient to suffer harm, right? So, and to do so, you have 4 legal elements that have to be proven. So, first, the provider must have had a professional duty that was owed to the patient. So they were the patient's doctor, right? They were the provider. And there was a contract between the two. There was a breach of their duty, so they failed to do something, or they did something that was inappropriate, or something caused, there's something that didn't go right. And there was injury to the patient that was caused by this breach of duty from the provider. And then there are damages that sometimes are permanent. Money damages, if awarded, typically take into account both the actual economic loss and non-economic loss, such as pain and suffering. So actual economic loss could be, the cost of the procedure, maybe salary from time missed at work, something like that. And then, of course, non-economic loss, pain and suffering. That is self-explanatory. So the basics of healthcare torts. So negligence involves the unintentional act or the omission of an act that would contribute to the positive health of a patient. So again, failing to do something, and again, not intentionally, just something gets overlooked, something doesn't get done, a medication doesn't get given, or something like that. It's never with intention, right? So an example of negligence would be if a provider does not give appropriate care or withholds care that results in damages to the patient. So either the procedure that was supposed to be done is not done correctly, there's harm, such as, and sometimes, like, when you're having a procedure, there are risks that are involved in it. The physician tells you that, right? You can have, bleeding, or, perforation of an organ or something like that if you're having a certain procedure. And so if they don't follow the proper protocol or didn't do things right, that could be maybe a case of negligence. But it can be difficult, of course, because you have to prove that they didn't do things properly, right? Intentional torts are known also as assault and battery or invasion of privacy. In the healthcare industry, an example of that would be a surgeon performing surgery on a patient without their consent, or performing surgery on the wrong limb, or doing the wrong procedure, or something like that. So that's considered assault and battery. Invasion of privacy would be, sharing information that is private. It's invasion of privacy. So let's talk a little bit about tort reform. So as a result of the number of malpractice claims in the U.S., malpractice insurance premiums have increased. And of course, then that increases the cost of health care. So this also has resulted in the concept of defensive medicine on the provider end, which means that providers often order more tests and provide more services than are necessary to protect themselves from a malpractice lawsuit. So they're afraid they're going to miss something, so they do absolutely everything, and sometimes way too much. And if you do that, for example, in an emergency room, what happens is there tends to be a backlog of patients. Patients don't move through the ER as quickly as they should. and the cost of caring for the patient is, again, more expensive. So then that also drives healthcare costs up. More states have adopted statutory caps on monetary damages that a plaintiff can recover in malpractice claims to try to limit the amount of malpractice suits. The states felt that a cap on monetary damages would have the most impact on malpractice insurance premiums, because the less an insurance company has paid out in insurance claims, the less the insurance company would have to raise insurance rates. And that's, of course, assuming that the insurance companies would not simply pocket the increased profits. Many legal factors have contributed to the increase in claims. So voluntary hospitals are no longer exempt from malpractice suits, whereas they used to be, because they were not like a human being, basically. So, but they are now also legal entities, and so they can be sued. Employers also now have to take responsibility for their employees' wrongdoing, so that has also increased claims. So again, you can sue the clinic, sue the hospital. And then the concept of informed consent for the patient has expanded and therefore increased claims. So if you don't provide good informed consent, then the patient may not be aware of what they're signing up for, and that could lead to lawsuits down the road. So the acceptable standard of care, so that's, again, a concept that's really important, which used to be strictly based on the locality rule, meaning on that's how we do it rule, which is not appropriate because every hospital had its own little standards. But now we have state or even national standards for standard of care within the different practices. And so that has also resulted in an increase in claim, because you can look and see, oh, this was the standard of care, is not what the practitioner did, and therefore you have a basis for a lawsuit. Recent federal studies have indicated that imposing caps on awards may be an effective method to reduce malpractice costs and to discourage at least the frivolous lawsuits. So, because you can't get as much, so for the even for the lawyers, to invest their time into a case, they must be able to recover enough money. It must be worth it. And so putting a cap on awards then makes them think twice about just, again, lawsuits that maybe don't have any merit. The U.S. Supreme Court ruled that any awards must be included in an individual's tax income, and so therefore they're taxable. So let's talk a little bit about healthcare fraud. The most common criminal violation in the healthcare industry is healthcare fraud, which typically involves illegal acts for financial gain. So fraud can be perpetrated by a variety of healthcare stakeholders. It could be multi-state organized crime rings that improperly bill Medicare for $40 million of home health care, or it could be a single fraudulent clinician. But it is costing a lot of money in our healthcare system. So we established a Medicare fraud strike force. It was established in 2007. This task force uses both federal and local law enforcement agencies to combat healthcare fraud. There are over 15 strike forces nationwide. In 2018, the Appalachian Strike Force was formed to combat opioid abuse. And for every dollar that is spent on these types of activities in the last 3 years, they have recouped $4. This is from the OIG in 2021. The centerpiece for fraud recovery is the False Claims Act. So it is money well spent because they get the money back. So the False Claim Act, which is also known as the Lincoln Law, was enacted in 1863. It was originally passed to protect the federal government against defense contractors during the Civil War. The False Claims Act has been amended several times throughout the years, and in the 1990s it was amended with a focus on healthcare fraud, most notably on Medicare and Medicaid fraud. So the False Claim Act of 1995 imposes criminal penalties on anyone who tries to present fictitious claim or false claims for payment to the federal government. So this would be, a clinician, for example, billing for services they didn't render for a patient, so that's a false claim. or, again, billing for services usually not provided is the biggest way that, this is done. So this False Claims Act is one of the most powerful government tools to combat civil fraud in healthcare. It provides financial incentives for whistleblowers. So this allows employees to blow the whistle about contractor fraud against the federal government. So if somebody notices this is going on, they can anonymously, or there's no repercussion for the employee that reports it. And there's even some bonuses and incentives that are given. The Fraud Enforcement and Recovery Act of 2009, FARA, and ACA of 2010 furthered and strengthened the False Claims Act. They expanded the potential liability for false claims by applying the False Claim Act to a broader range of transactions, by reducing the proof required to establish illegal activities, by expanding the pool of potential whistleblowers, and may bring retaliation claims. The ACA also provided an additional $350 million over 10 years to help fund new initiatives to effectively fight fraud. It also called for more stringent federal sentencing guides for healthcare fraud. So really focusing on, putting all this fraud down, because we can't afford to have all of this excess money that's not even going to care, and our healthcare expenses already so high. Okay, so that we're going to stop here, and we're going to continue in the next lesson. I have a lot more on healthcare law for you.